Hello there, and welcome back to Ask a Lawyer here on CP24. We are back for another week. John Scholes here, and on your screen momentarily, my good pal, employment lawyer Lior Samfiru from EmploymentLawyer.ca. As we always tell you right off the top, reach out to Lior with any concerns. Don't sit and wonder and make mistakes on your own. Get the right information. That number, 1-855-821-5900. Ask at EmploymentLawyer.ca. And for any other concerns, the website, it's free, it's anonymous, plus access to what we call the severance pay calculator. That can all be found at pocketemploymentlawyer.ca. Over 2 million Canadians have used that severance calculator, so take that for a spin, and it'll be on display here shortly as we get through the half hour. Main topic, as always, in the second segment is going to be things employees should never do. Not the obvious stuff like put your boss in a rear naked choke till he taps out. We're not talking that. We're talking things you may not realize you shouldn't be doing, at least until you talk to an employment lawyer. That's coming up in just a bit. Some phone calls, emails. It's a busy show, as always, Lior, but we always get things warmed up. You do that for us right there with a case of the day, or a week that was. Pal, what do you got going on this week?
Rear naked chokehold. No, you're right. We're against that here. We will not be advocating violence here in any way, shape, or form. But what we will be doing is talking about your legal rights, your employment law rights, what your boss can and cannot do, what you should be doing and should not be doing to resolve those workplace issues. You have rights. They're quite extensive. There's rights in almost every situation. People don't know what they are. People get confused. There's a lot of misinformation out there. On this show, you don't have to worry about that. You just get the straight goods, the straight truth. If you want to know what to do and what your rights are, if you've lost your job, if your job has changed, if your company is being sold, if you're being mistreated, or maybe you're just not being given information by your employer about your future plans. In any of those situations, the law says, hey, not so fast. Here's what we're going to do. Here's the options. Here's the rights that you have. So if you want to know more about your rights, which everyone should know, this is the time and place. But of course, 30 minutes is just going to fly by. Beyond these 30 minutes, very easy to connect with me and my team across the country, frankly, so we can have a private discussion about your legal rights. So we'll give you that contact information on the screen throughout the show. But enough of that. Case of the day, where I always like to start. I spoke with a lady that unfortunately found herself in a very difficult situation, probably kind of everyone's worst nightmare. She was diagnosed with a very, very serious medical condition. One of those conditions, well, it's not clear yet what end game is for her. Is she going to be able to beat this and get through it? So obviously she had to go off work. She told her employer exactly what her condition was. She was open and honest. Wouldn't you know it, after a couple of weeks of being off, her employer sends her a letter by registered mail saying, well, given the seriousness of your condition, we don't expect that you will be able to come back to work ever. We call this a frustration of contract. So we're going to end the relationship with you. Of course, we wish you all the very best in the future. She is very distraught. Again, very bad situation, worst nightmare, completely sick. Now her employer saying, yeah, we're writing you off. We're not going to even have your job for you. So she calls me and she wants to understand her rights. So what is this concept of frustration of contract? In this context, the frustration of contract would happen if an employee has been off for so long and their condition is not improving that it's clear they're not going to be coming back to work. In that situation, the employer can end employment with very limited obligations. But that's not this case. She's only been off for a couple of weeks. Her doctors have not concluded she's not going to be back to work. She's working on it. She's hoping to get better. While the future may be unknown, after 2 weeks, no one can say frustration of contract. Now, if she's been off for a year or 2 years and she's not getting better, yes, potentially at that point. Not now. So what does this mean? This means this is a wrongful dismissal. She's owed severance. But beyond that, this is potentially a human rights violation. She's being let go because of the serious nature of her medical condition and the employer just not wanting to wait. That is illegal. So I'm going to deal with this employer. I'm going to make sure that they abide by their legal obligation. But I wanted to remind everyone there that you can be off work if you're sick, and that does not mean that the employer can just end your employment. That is not allowed. You can be off even for a long period of time and still maintain your rights as an employee. If your employer ends relationship with you, won't let you come back to work, tells you you're too sick to be coming back to work, call me just this lady did, and let me help you.
Brilliant start, as always, Lior. Thank you very much for that. We have time to get to a viewer phone call. Again, reach out to Lior anytime and go to EmploymentLawyer.ca to find a radio station across the country that carries our show as well. So listen up here, Lior. First phone call of the show is coming up right now.
Been working full-time running a restaurant for the last 9 years. I got hit with a medical issue that landed me in hospital, and I let the ownership know right away that I had side effects, but I had no idea how long it was going to be on a medical leave. So I kept in touch with them every month or two. I got clearance for the doctor in March to finally start working. Contacted them that I've got my ability back to work. However, I found a job posting on the company's website for my position about a month or so before that.
So obviously, if a company has an employee that's been gone for a while, they have a right to continue operating their business, and that may mean hiring a replacement. So if a replacement is being hired, and when the person is ready to come back to work, if there's no job available, the employer's tried, but there isn't. They hired someone. They don't have to fire the new person. At that point, they are allowed to terminate employment with severance. It sounds like this is what happened here, but the issue is he is owed severance. You can't just say, hey, I don't have a job for you, so I'm not going to pay you severance. Absolutely not. Severance has to be paid. So then what do we have to do? Well, we have to figure out how much severance he is actually owed in this situation. We're going to use our favorite tool, the severance calculator. You'll find that at PocketEmploymentLawyer.ca. Again, PocketEmploymentLawyer.ca. Let's use that right now and see what we get. So he's in a restaurant manager role, 56 years of age, been there for 9 years. Company doesn't feel they have to pay severance. Nonsense. They owe as much as 14 months. You see that on the screen right there. 14 months severance. He's been wrongfully dismissed. If you want to know how much severance you're owed, which, by the way, you're almost always owed if you lost your job, just check out PocketEmploymentLawyer.ca.
All right, Lior, thank you so much. We got to get into a quick break here. On the other side, the main topic time again, things employees should never do, at least until talking to an employment lawyer. That is on the other side as we continue to roll on here. Ask a Lawyer on CP24. Stay with us.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
Okay, we are back here to Ask a Lawyer on CP24. Thank you so much for hanging through the break. John Scholes here, Lior Samfiru as well. Always reach out to Lior with any questions when the show's not on, as you know. The phone number, 1-855-821-5900. You can email ask@employmentlawyer.ca. Scan that QR code as well. And we always kick off this segment, Lior, as you know, with the main topic, and it is things you should never do as an employee, at least until talking to you. The first one, again, these may not be obvious to most people, but accept significant unwanted changes to their job, right?
Yeah, you don't want to accept significant unwanted changes to your job. So let's break this down. An employer does not have a right to make significant changes to your job, to reduce your pay, to demote you, to give you different hours. But if you decide to accept them, the problem with accepting them is now you've given the company the right to do it again and again and again. So you may look at it as a one-time thing. Okay, I'll just accept this one pay cut. The problem is you accept that pay cut, now the company can do it again, and the next time they do it, you won't be able to say, I'm not accepting, because you let it happen that first time. You have to be very, very careful about that. So what options do you have instead of accepting? You may be able to consider that significant unwanted change as a constructive dismissal. You may be able to say, well, no. By reducing my pay, by changing a significant term of employment, I can treat that as a termination and get my full severance. That may be better than opening the door to future changes. So if you're facing a change like that, it could be a constructive dismissal. Before you do anything, we need to talk.
Number 2 on our list, Lior, is this: do not stay silent if you receive a bad performance review from your employer.
So if you're getting a bad performance review and it's justified, it's correct, okay, it is what it is. Do what you can to get better. But if it's not justified, it's not correct, it's not factual, you have to say something about it. And the reason you have to say something is silence is the same as acceptance. It's the same as you saying, hey, I'm okay with that. This is correct. And that can be used against you in the future to justify a termination. So you can't be silent. Well, what do you do if you get a negative performance review or you're put on a performance improvement plan and you don't agree with it? I want you to send an email in writing, of course, saying, here's why I don't agree with it, or here's what facts you're not considering, here's what else you need to know. Put that in writing. It doesn't have to be extensive. You don't want to be aggressive about it, just very factual. You don't need a response from the company, but put that in writing. By doing that, you're going to make it very difficult for the company to hold that negative review against you.
And finally, Lior, the final one for this segment, released for this topic this week, and it's a big one too. Don't accept or sign back a severance offer on the spot. Never do that.
In fact, I'll expand that. Don't accept it at all without speaking to me, without getting proper legal advice, certainly not on the spot. There's a 90+% chance that whatever you've been offered is not even close to being adequate, not even close. I'm talking about very, very poor. So if you accept it because you don't know any better, you feel that pressure, you may not be able to get out of it. Please don't do that. Do the smart thing, do the right thing. I know you're feeling that pressure. I know you're thinking you have no options. You do. The law's on your side. I'm on your side. Let's make sure you get what you're owed. Please don't be one of those people that contact me every week saying, I realized I made a mistake. I signed off on that offer. Now I want your help. I can't help in that situation. Speak to me before you sign. Let's make sure you get what you're owed.
All right, Leo, let's keep going here. We got some time. Get to our second phone call of the show from one of our viewers. Listen up.
My neighbor, who runs a successful small business, says that most of the rules you talk about on your show don't apply to him, only to large employers. Is he?
No.
I'm going to make it very, very clear. Everything I've ever said on this show, on my radio shows, everything you may have heard me say otherwise on TV or read in an article, all of that, without exception, applies to all employers, small, large, medium-sized. It applies whether you work for a company with 2 employees or 2,000 employees. The laws are the same. The laws don't discriminate. The laws don't discriminate between big employers or small employers. So if you hear me talk about your full severance, that applies to big companies and small companies. If you hear me talk about constructive dismissal, human rights violations, rights when it comes to bullying and harassment, all those and every other law still applies to you without any regard to the size of the company that you work for. So small employers still have to pay you your full severance up to 24 months pay, same as big employers. So yeah, there's no distinction based on size, John.
We will take a short break here, Lior, and give you time to put on your disability law hat, and we'll continue that topic on the other side of the break as we roll with more Ask a Lawyer on CP24. Don't go anywhere.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
We are back. Thank you so much. Ask a Lawyer continues. We switch gears a little bit for this segment and talk about disability law. It's the other half of what the firm does with Lior. The phone number is the same, right? As you know, 1-855-821-5900. Email, slightly different. Ask at disabilityrights.ca. But again, you can scan that QR code anytime you would like. As I just mentioned, Lior, we're kind of switch gears here a little bit. Break it down quickly what the difference is between the two pathways inside the firm, right?
So our employment team deals with disputes between individuals and their employers. Our disability team deals in disputes between individuals and insurance companies or government bodies that have to pay them disability rights. And the reason why we have a team is because these issues come up too often where people are entitled to get paid by an insurance company or by the government, and they're denied, they're being cut off, the government doesn't believe them, and they're left holding the bag in a difficult situation. We have a fantastic team dealing exclusively with this. So if you're denied disability benefits, being cut off disability benefits, if the disability insurer doesn't listen to you or your doctor, call me and let's connect with my team.
All right, we'll keep it going. We have a listener viewer question right now, Lior, so listen up to this one.
I've been working for this company for a long period of time. Been off for just under 2 years on a long-term disability matter. And I got notification earlier this year that my claim was being terminated. So I reached out to the employer and I explained to them what was happening. They basically just wiped their hands with it and said, well, that's not us, it's the insurance company you got to deal with. Just trying to figure out if the employer has any obligation to the employee.
Yep, there you go.
So, John, in this case, the employer is actually right. That dispute is between the individual and the insurance company. They decide if the claim is valid, if the person qualifies, not the employer. The key is to understand that this insurance company, or most insurance companies, get it wrong very, very often. The insurance company often cuts off or denies a claim or ends the claim before they should because they don't think that the employee is really that sick. They don't believe the employee, or maybe they just hope the employee won't do anything about it. So bottom line is, now that you know that, don't let them get away with it. If you cannot work and you know you cannot work, your doctor is telling you cannot work, let us deal with that insurance company. They will deal with us very, very differently, and they'll pay what they have to pay.
Let me get a quick email question into you, Lior's as well from our disability side. It says, can my insurer deny long COVID disability because there's no objective evidence? What do you think?
Well, no, they cannot. You know, COVID is one of those diseases, one of those conditions where it's difficult to see on an X-ray. You know, many other conditions are like that as well. You're not going to be able to have an X-ray and get COVID, and sometimes even those tests are not accurate. The bottom line is this. That diagnosis is not as important. What's important is, do you have a medical condition that's preventing you from working? Is your doctor supporting you? And if your doctor contacts you and asks you for evidence and you put them in touch with your doctor, they should listen to that doctor, okay? Long COVID is a real thing. It's maybe difficult to diagnose, but you don't see that on an X-ray. If your doctor says that's what you have and that you cannot work, your insurance company should be paying for that, should be paying you those benefits, and they should not be denying you, claiming that they don't have enough evidence. That's improper.
All right, Lior, thank you so much. Appreciate that. Stick around, though. We're going to take a short break and wrap up the show this week with a phone call. That is on the other side as we continue. Ask a Lawyer. Stay with us.
Lost your job? Disability denied? Ask a Lawyer is here for you. Each week, experts from EmploymentLawyer.ca answer your questions. Visit cp24.com/askalawyer and watch Mondays and Wednesdays at 9 p.m. on CP24.
We are back to Ask a Lawyer. Thank you so much here, CP24. Lior Samfiru, reach out to Employment Lawyer anytime. Phone call 1-855-821-5900. Ask at EmploymentLawyer.ca to do that. We really like to wrap the shows up most weeks with a phone call from one of our viewers because you always learn a lot from them, Lior. In that regard, we're going to get to that phone call right now and see if we can answer this one to wrap up the show this week.
We were given written notice in December that our job would end the end of May. At the end of May, it'll be 13 years. I'm 75. At first, because we were given written notice, we understood that they weren't going to pay any severance. Of course, we have stayed on because there was rumor that we might get something. I just want to know what we're entitled to. Clerical.
So the first thing I'm going to say is that when you get advance notice of your termination date, that notice, that amount of time that you were given as notice counts towards your severance. So if you're given 2 months notice, 6 months notice, that amount of time counts towards your severance entitlements. But it doesn't eliminate your severance entitlements, it just counts towards it. So in this case, this person got 6 months or so notice from December to May of the termination of employment. So if they were only owed 6 months severance and they got 6 months notice, they wouldn't be owed any more severance. The real question is additional severance owed? If additional severance is owed, the employer has to make up that difference by paying it. They don't get to avoid it. And by the way, this is a restaurant, small business potentially. Small business, large business have to abide by their legal obligation. They have to pay full severance either way. So what we need to know is understand whether this person has entitlements above and beyond the 6 months notice they got. So we're going to go one more time on the show and use the severance calculator. You can find that at pocketemploymentlawyer.ca. I'm going to use that right now and see what we get. So this person is 75 years of age in a clerical role, been there for 13 years. Company gave 6 months notice, but what we see there that she's owed 16 months of severance. She got 6 months, so there's a difference there of about 10 months that the company has to pay. So that's why it's important to go to that severance calculator, by the way. It's completely free. It's completely anonymous. If, like this person, you've lost your job, it should be the very first place you go to. If you're curious about your entitlements, you check it out, or just maybe you want to know, pocketemploymentlawyer.ca.
You know, Lior, that one's interesting because, if you looked on the Pocket Employment Lawyer readout there, I mean, this is one of those cases where the actual compensation owed eclipses the year's worked. It's more than a month per year. Does the age have something to do with that? Because this person was 75, right?
John, that's such an important question because people often believe that, well, there's a rule of a week per year, 2 weeks per year, a month per year. No, nonsense. None of those rules exist. They simply do not exist. Entitlements are based on age, position, and length of employment. So yes, a 75-year-old person with 13 years of service is going to get a lot more severance than a 35-year-old person with 13 years of service, because that age matters. For her, that's more than a month per year. Some people can be less than that. That's why you have to use that severance calculator. That's why we've created it. That's why over 2 million people have used it, because it tells you what you need to know. It's not this nonsense of these rules of thumb. Again, pocketemploymentlawyer.ca, and just click on the severance calculator.
And that'll just about do it, Lior. It is free and anonymous, by the way. Again, pocketemploymentlawyer.ca. Beyond that, always reach out by phone, by email, 1-855-821-5900. Combine that with ask@employmentlawyer.ca, and you are completely covered. Beyond that, cp24.com/ask-a-lawyer to reach out any other way and look at past episodes as well. Thank you so much for your contributions, your phone calls, emails every week. We will continue on and on. We'll do it again next week. Until then, thank you so much for watching.